Well, hey there, folks. My name is Walton Dabney. I'm an attorney with Beresford Booth, and we're going to be talking today about when parents disagree about medical treatment and vaccines. We're going to move on to the next slide here. So here we go. Here's what we're going to talk about. We're going to talk about a provider's perspective, the parent's perspective, and the court's perspective, with a special emphasis on vaccines and some key argument points that you're going to want to come away with. A little bit about me. In addition to being a family law attorney in one of the most preeminent law firms in all of Edmonds, Washington, in my previous life, I was also a medical law consultant for multiple hospitals through the United States. So I come at it from both perspectives. Whenever providers had questions about what to do when parents disagreed about a child's medical treatment, they came to me. Whenever they got subpoenas that conflicted with other subpoenas, they came to me. Now I represent the parents. And so I want to give you my perspective from both sides in the hopes that we can arm you with the information you need to get what you need done for your kids. Or if you're a provider, to get what you need done, again, for the children and also for the best interest of your own practice. So let's start with providers. Now, parents are going to make a decision about a child's healthcare and their treatment. The law is also going to make those decisions, and then sometimes you, as the medical provider, are going to have the option to make those decisions. Now, when the parents agree, you're golden. So long as they're not agreeing to some sort of treatment that's going to negatively impact the child's health in a demonstrative way, then you can go forward with that treatment, whatever that treatment is. When the parents disagree, hopefully there is already a court order in place, and then you can just follow that court order. That usually comes in the form of a parenting plan. When you don't have that parenting plan, there may be other court orders, emergency orders, for example, that will be provided to you from either parent. Rarely, occasionally, the court itself could sua sponte provide you, the provider, with an order. But for the most part, those orders are going to be coming from one or the other. When you receive them, it's a good idea to talk to an attorney if you're not sure what they mean. Always err on the side of talking to an attorney. If you don't know whether or not you should call a lawyer, that means you should call a lawyer. Now, if there is no explicit agreement, nor is there an explicit court order, but the parents are still in disagreement, you're going to base it off of who has the parenting time, who is actually showing up with the child at the appointment. Parents have the right to see to medical conditions, emergency and otherwise, with their children during their parenting time, barring some other court order or some other agreement. So if mom shows up and she wants to have the child treated for a rash, for example, and then in the process, the father calls up and the father says, I don't want my child treated for a rash, and I do not give my consent. Well, in most cases, since the rash is not particularly urgent, what you would probably get advice from your lawyer is to kind of step back a little bit and see if either one of them have an explicit court order, or if there's an order in existence that either one of them know about, and then try to figure out which one has parenting time. There's also law that's going to impact how you treat kids and what you can reveal about their treatment. And any provider who is a provider knows about HIPAA, and HIPAA puts rules on how to release a child's information. Usually, if somebody has the authority to consent to a procedure, that means they also have the authority to receive information about that procedure. The parents in general, both parents, are going to have access to those medical records. The only time a parent is not going to have access to medical records for their children is if there's a court order that says otherwise. And again, it's not up to you as the provider to figure that out. Instead, the parents are supposed to be bringing you that information. And then if the information is difficult to understand, talk to a lawyer about it. Now, of course, we all have a duty to report when it comes to a situation in which children could be harmed. If you find that there's some sort of abuse going on that could get to the point where the child is in danger, you have a duty to report, even if one or both parents disagree with that. So So that's one of the ways in which the law kind of trumps both parents' decisions. Subpoenas are an interesting one, and that when a subpoena comes to you, the subpoenas are supposed to be very formal sounding. They're supposed to make it sound like you, the reader, have the force of the entire government laying upon you, demanding that you do this thing. In most cases, subpoenas are written by attorneys, not necessarily by the court. Now, attorneys have that authority through because we are officers of the court, but those subpoenas can be what's called quashed. They can be objected to, and that's something that you're going to want to talk to your attorneys about. And then, if it is directly in contrast to what the other parent wants, fill the other parent in. You're not required to keep subpoenas a secret from other parties in a civil lawsuit or a civil action or a family law action, and give them the opportunity to respond, to talk to their attorneys, to get something filed with you so that you can make a decision about which direction you want to go. And then, of course, there's situations in which the courts or the parents don't have a say, and the medical provider is the one who makes the determination for what happens to the child. And that pretty much only happens in very emergent situations, emergency situations where life and limb is at risk. At that point, if the child will die unless you perform a certain well-known emergency procedure that's well within the standard of care, then you can perform that procedure for the most part. This entire webinar is not supposed to replace legal advice. You definitely want to talk to your attorneys about what to do in those situations. But erring on the side of saving a child's life or arm or leg, courts are going to be forgiving about that for the most part. So here's another aspect in which the parents don't necessarily have a say. Here in Washington, children can have certain procedures done, and they can consent to it themselves. People of any age can get birth control, abortion, and abortion-related services in prenatal care. And in those situations, the parents don't necessarily need to be informed. In some cases, they do. And we're not going to go into too much detail about every single possible permutation of what might cause the parents to be informed. But in many cases, birth control, abortion, and prenatal care, the parents don't necessarily need to be informed. People 13 and over in Washington can consent to mental health treatment, but in most cases, the provider must notify the parents or guardians for that matter. Inpatient substance abuse use disorder and treatment, the providers may notify the parents or guardians. In most cases, it's going to be a good idea, but there may be certain situations where it's not a good idea. And that will be determined on the provider's perspective. And of course, whether or not the child consents and the application of the appropriate law. Again, talk to your attorney. People 14 and over can consent to tests and treatment for sexually transmitted diseases. There's no requirement in the law that parents need to be informed about that. And then somebody of any age who is married to an adult or is an emancipated minor themselves can consent to all of that, all other treatment, and vaccines. Now here we are, we're bringing up vaccines, whereas before we didn't. Otherwise, there is not an explicit permission in Washington law for minors to consent to vaccines on their own unless they are married to an adult or emancipated themselves. So let's now change gears here and talk about the parent's perspective. Why do you want what you want? In cases of mental health treatment, medical treatment, and pretty much anything else that you could dispute with your co-parent, you want to ask yourself, what is your ultimate goal as a parent? And then most people's ultimate goal is for their child to grow up happy and prosperous, healthy and safe. And only then should you determine what your secondary goals are. Your secondary goals, those are the ones that you think will lead to the ultimate goal. I want my child vaccinated from COVID-19 because I believe that will serve my ultimate goal. I want my children to have braces on their teeth because I believe that will serve their ultimate goal. The thing about secondary goals is they're not as important as ultimate goals. And if there are other ways of getting to that ultimate goal, then you have a window there where you can successfully negotiate with the other parent. If you disagree about secondary goals, that's not necessarily an impasse. If you disagree about the ultimate goals, that's going to be an impasse. But most parents love their children and care about them and have the same ultimate goals. So I encourage you, whenever you're having these discussions, put everything in the right frame of mind. And you certainly don't want to live or die based on the tertiary goals, those third level goals, the little logistics aspects of those goals, like I want to show up at this appointment on this time, or I wish to see this doctor and not that doctor. Those are goals which serve the secondary goals, which themselves are serving the ultimate goals. And the further along you get from the ultimate goal, the less important it is to stick to that and not negotiate. So the first thing parents should do when determining the best situation for their children is keep in mind what's important and what's not so important, and what's not really important at all when negotiating. Now, when you get to that point, when you've narrowed it down and you said, okay, we cannot get past this point, we've reached an impasse, we do need to start agreements. And we just need to, if there's no agreements, then we need to start arguments in front of the court. How to get what you want, first and foremost, is by agreement. That's usually the best way, because you know that ultimately what's going to happen is something you've consented to. But if you can't get there, then, and there is no court order in place, then you need to remember your time, your rules. Your parenting plan is going to have both parents have time to be with the children. When it is your time, it is your call whether or not they go to physical therapy appointments or situations where that's going to impact that time, non-emergency or an emergency treatment. If your parenting plan doesn't say otherwise, doesn't say that it needs to be joint authorization, then when you're in control of the children, you're in control of the children's health care. Now, if there's a disagreement and you are concerned that your co-parent is going to make a decision that's going to have significant long-term consequences on the child, like getting a particular vaccine or getting braces on their teeth, and there is no court order or parenting plan, you better file one. As a parent, you do not have a right to necessarily march in and say, I refuse to let this happen on my co-parent's parenting time. You're not in charge and cannot dictate your co-parent's parenting time. You can only dictate your own. So you're going to want to get a court order, and that would normally require hiring an attorney. It doesn't necessarily require, you could do a pro se, but I highly do not recommend that. And if it's going to be something that's happening soon, it's going to need to be an emergency court order to try to get a temporary parenting plan in place to prevent any long-term or permanent decisions being made about the child's welfare until you either come to an agreement or the court can make a decision. Something you don't want to do is do self-help. You don't want to charge into the doctor's office and insist that I'm taking my child away now because you're trying to harm them by giving them a vaccine or giving them braces or any number of things. You're going to start to shade into illegality there. You don't have the ultimate right to do whatever you want if you can justify it as being related to the children, especially when it's in direct contrary nature to the co-parent who has equal rights as you do. So come to an agreement. If you can, focus on your time in the parenting plan. And if you're concerned about something they're going to do on their time, you're going to need to file a court order and you're going to need to get it addressed in your parenting plan. So when you get that filed, when you start actually fighting, what is the court going to think? Well, the court primarily, first and foremost, is supposed to focus on the best interest of the children. And in some cases, it is objective, in the Washington law occasionally dictates precisely what the best interests of the children are in a circumstance, but for the most part, it is subjective, which means the court is going to look at all of the evidence presented to it to make a decision about fact. The court is the fact finder. you can say in your argument, the fact is blah, 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 and the fact is blah, blah, blah. But the court is the one who determines what the actual facts are. And they're going to determine that based on the evidence you bring. Evidence is going to weigh more than argument. Standing up there in the hearing room, in courtroom 1C in the Snohomish Superior Court, you can argue until you're blue in the face or until the commissioner stops you. But they should be making their decision based on the actual arguments, the actual evidence in front of them. And your testimony, your statement does count as evidence, but actual corroborating evidence in addition to that is going to be better. And it's going to be what sways the court. You should base your arguments on accepted facts and evidence of those facts. And that's important when we're talking about health, when we're talking about mental health, when we're talking about vaccines. People have strong opinions, especially nowadays. But those opinions don't count as evidence. There could be studies. Go ahead and grab those studies and try to argue those studies. Better yet, try to get a doctor who can agree with you and who can write a statement regarding this situation, or perhaps even show up at the hearing to testify. Your arguments should be based on facts that are already accepted by the court or will be accepted if they accept your evidence. For example, stating that the COVID-19 vaccine is the mark of the beast. Okay, you may believe that. Heck, that may even be true, but that is not an accepted fact of the court. So if your entire argument revolves around my child shouldn't get the vaccine because it is the mark of the beast, that argument's not going to fly. Now, if you base your argument around your religious freedom to raise your child in whatever religious doctrine you choose to raise it in, that your freedom, your First Amendment rights, are an established fact and law that the court recognizes and understands. So it depends on what they are actually already agreeing to are the facts. Base your arguments on those. Now, when one side provides evidence and another side provides evidence, how does the court make a decision? Well, keep in mind that the fact finder, and again, we're talking by the fact finder, we mean the judge, or more likely the commissioner, is going to be making their decision based on multiple factors. And one of them is their, quote, knowledge of the ways of the world, unquote, which means they can kind of metagame this for you gamers out there. They can say that, I've seen this a million times. I know what happens when I make this decision. I know what happens when I make that decision. And I know that braces are good for kids' teeth. And so therefore, based on my knowledge of the ways of the world, I'm going to add that to my decision on what the facts are. They can do that. And they can do that even if neither side provides any evidence about braces in that case. But for the most part, they like to rely on the evidence that's presented in front of them. Now, there is a hierarchy of evidence when it comes to arguing about medical procedures for kids. Professional opinions are gonna trump layman opinions. The professional opinions simply win. So if one side has a doctor saying in a statement or testifying, this child needs this procedure for this reason, it is my professional opinion they do. And the parent says, well, I'm a parent, therefore I have a right to have my opinion heard, and my personal opinion is they do not need this procedure. The court's going to choose the doctor over the layman opinion, because ultimately, back to the top of the slide, they're looking out for the best interest of the children. So if you know that there's going to be a professional opinion out there, you're going to need to try to counter it with a professional opinion. And then when you do, when it's professional versus professional, you want something that is directly related to the patient, to the child. So there could be a treatise out there about how a certain procedure is bad or bad for particular children. And you could use that as evidence, and that would be legitimate evidence. And that would be professional evidence. But then you have another professional opinion who says, I treated the child, or I examined the child specifically, or I examined the child's records, and I'm applying my knowledge, my professional knowledge, specifically to this child. And in this child's case, insert whatever it is you want to argue there. And in that case, the professional who pays attention to the child and does a direct examination on the child or the child's records, those are typically the ones to win. So if you know that they're using professional opinions, you want professional opinions that focus on the child itself, not on nebulous concepts of whether or not a particular thing is good or bad. Now, let's say two doctors have reviewed the child's record and or perhaps examined the child themselves. Then it gets kind of tricky. Then the fact finder, again, the commissioner or the judge, is going to be looking at the curricula vitae, the resume of both of the doctors. And in many cases, especially in jury cases, which you're not going to have in family law, but in many cases, the fact finders simply in their mind cancel out both opinion witnesses. If they're both good opinion witnesses and they both have the same access to the kids and they're saying opposite things, oftentimes they cancel each other out. And that might be the best you can hope for if you're going up against expert opinion evidence. And in that case, the fact finder is going to go back to other evidence they've heard and had in front of them and their knowledge and ways of the world. So keep that in mind. There is not any particular piece of evidence you can give to a fact finder, to a judicial officer, which is a guaranteed win. You need to take into account the hierarchy of how they examine these things and get yourself an attorney, preferably who's worked in that court, maybe even with that commissioner. So, vaccines specifically. As I said, children, people under the age of 18, cannot consent to vaccines unless they're emancipated minors or they're married to an adult, which can happen in Washington. Adult being somebody over the age of 18. Now, when you're arguing whether or not your child should or should not have a vaccine, you want to throw all the information you have in front of the court, not just those expert opinions, although those can be very useful. But non-medical factors are going to play a role too. If the child cannot attend school because they don't have a particular vaccine, the court is going to factor that in favor of the vaccine because the child attending school is in the child's best interests. If the child cannot travel, and travel is an important part of the child's life, for example, they have parents in different states, or grandparents, or a school program, or some sort of opportunity that would negatively impact the child if they can't travel, that's going to factor into the vaccination, even though it has nothing to do with how the vaccination will actually affect them. Risk to others. This is especially a hot button thing with COVID-19. One of the factors could be that it might not impact the child at all, one way or the other, but if they carry a virus, COVID-19, and they give it to their grandfather that they're visiting, and the grandfather could be at risk, it will either prevent them from interacting with their grandfather face-to-face, or could cause damage to the grandfather's health, which would then negatively impact the child. So these are not the only three non-medical factors. These are just the first three that are the most common. There's plenty of other ways to attack this and add to your argument in favor or against vaccinations. All three of those factors and others could work to argue against the vaccinations. Although if you're going to argue against the vaccinations, you really want to go back to the expert evidence that we mentioned and get yourself a provider who examines the child specifically and the child's history and perhaps the family history and make an expert determination that is in your favor. So the current mood of the Washington courts, and that's what, and I say mood because moods can change and moods are entirely subjective and not written down anywhere. And by the time I'm done with this PowerPoint, perhaps the mood has changed. But currently, judicial officers are going to default to the health guidelines if no parents object, because it's a nice black and white thing that they can reference and they don't have to use a subjective decision-making process. They can just say, these are the guidelines, go with the guidelines at the end. If the parents do object, then they're going to have to make an evidence-based determination on what facts are relevant to the situation, and then ultimately what's in the child's best interest. Judicial officers are people. And so they're going to have biases, and what their biases are, and how implicit or explicit their biases factor into their decision-making progress, that's going to vary. But all of them, regardless of how biased they are, all judicial officers are going to apply facts in evidence to make determinations. Therefore, the most efficient way to win an argument is a medical provider stating explicitly that this specific child must or must not be vaccinated. I said earlier there's no silver bullet, but that's pretty darn close to being a silver bullet. So you're going to want to focus on these key argument points. If you weren't paying attention to the rest of the webinar, pay attention to this one, okay? The children are not your property. They're a privilege. This gets so many people in trouble at hearings where they march into the room and they start talking about their kids in the lens of their own rights, their own constitutional rights. And we do have constitutional rights to raise our children the way we want them raised to an extent. But even though you have those rights, if you seem to the judicial officer like you are more focused on your own rights and your own dignity and your own offense at a particular thing, and less on the best interest of the children, the judicial officer is not going to take that kindly. They may even yell at you on the record. I've seen it done very recently. It wasn't me, it was somebody else, somebody who wasn't represented, by the way. Children are not your property, and this discussions and arguments about the kids are not about you and your rights. Let your attorney handle the rights issue. When you're speaking, focus on the best interests of the kids. There is no parental right that's greater than a child's right to be safe and healthy. So another key point is what we discussed earlier. Your opinions matter, but they don't matter as much as expert opinions. So if you know you're going up against an expert, don't try to simply argue that I read somewhere or I believe this, that, or the other. It's not going to be as persuasive as an actual expert. Get yourself an expert. Focus your argument on this particular child in this particular circumstance. Philosophies about all children should be vaccinated no matter what, or no child should be vaccinated no matter what, or general statements about the world, that's not going to be persuasive. Again, because then you're talking more about philosophy and your parental right to impose your philosophy on the child, which is not as important as the best interests of the child. You do have those rights, and those rights have been articulated all the way up to the state Supreme Court and higher in some cases. And sometimes you win. Those are very nuanced arguments, and they're not arguments that you're going to want to make without the assistance of an attorney. If you're going in alone, focus on the best interests of the children. All right, folks. So if you have any questions, feel free to contact me at waltond@beresfordlaw.com, and our number there, 425-776-4100. Thanks very much for your time, and have a great Washingtonian day.